Well, welcome. I see they've shut the door, which means it's time for us to start. I'm Susan Dudley at the George Washington University, Director of the Regulatory Studies Center there. And this panel is Policy Without Process. When I speak with people from other countries, I often emphasize the importance of the Administrative Procedure Act in the development of U.S. regulations. When it was passed in 1946, it reflected a compromise between those who were concerned that granting unelected executive branch agencies the power to write, administer, and enforce regulations was contrary to the Constitution. And those who argued that Congress needed to be able to delegate some legislative authority to experts in the executive branch who would be better able to make decisions on technical issues and to resolve controversial issues in a less political manner. So what the APA does is it constrains rulemaking in three basic ways. One is agencies can only act within the limits set by statutes. Second, they have to follow procedures, noticeably providing notice to the public of proposed regulatory actions and then considering those public comments before issuing a final rule. And third, the final regulations that are issued have to be based on the rulemaking record, thus giving federal judges and courts guidance on how to review and evaluate those regulations. So in many ways, this almost 70-year-old statute has stood up very well. And yet many commenters argued that federal agencies engage in practices that create and enforce policy without going through the notice and comment provisions of the APA. Now, this is not a new concern. The Office of Management and Budget in 2007 issued a bulletin on the appropriate use and procedures for developing guidance documents. And in both the 1970s and the 1990s, the Administrative Conference of the United States recommended procedures for engaging the public in guidance documents and interpretive rules. And in fact, we have two members from ACUS here today who might be able to tell us about this if it comes up, but ACUS is set to issue new recommendations later this year, providing policy guidance or on policy guidance that's issued concurrently with rulemaking. So we have three experts here to explore the use of policy tools that seem to evade the APA procedures, including guidance documents, executive orders, sue and settle agreements, and others. We're going to start with Jonathan Adler, who is, I should have asked you for pronunciation, the Johan Verhey, close enough, Memorial Professor of Law and Director for the Center of Business Law and Regulation at Case Western Reserve University School of Law. Then we'll hear from Bill Kovacs, who's Senior Vice President for Environment, Technology, and Regulatory Affairs at the U.S. Chamber of Commerce. And then to wrap us up, we'll hear from Stephen Vladeck, Professor of Law and Associate Dean for Scholarship at the American University Washington College of Law. So with that, I will turn, Jonathan's still quickly making notes on what he's going to say, but it's his turn. Jonathan.
Thank you. It's a pleasure to be here to talk to you today about Policy Without Process and to be at the Executive Branch Review Conference. As Susan noted, the problem that we're discussing is the problem of what happens when agencies engage in legislative-type rulemaking or other policy creation without going through the various procedures that Congress has declared that they should follow. And it's a problem in the administrative state because the administrative state, as Susan noted, is characterized by pervasive delegation of legislative authority to regulatory agencies. Agencies don't come with their own powers. They don't have inherent powers as agencies. They only have that authority given to them by Congress, and much of the authority that agencies have is the power to make policy, to enact rules with the force of law that define, limit, or constrain private activity, impose obligations, define rights that individuals have. Agencies are not merely limited to applying technical expertise to complex problems of administration or science and the like. That is essentially progressive. Agencies do. They are consistently making normative what the law should be, about what rules should bind conduct, about what among the various contested interpretations of statutes should be imposed, about what sorts of priorities should be made. And Congress has enacted various procedures to guide this process. Again, as Susan mentioned, primarily in the Administrative Procedure Act and then in subsequent revisions and additional laws imposing additional requirements, primarily to ensure that this process is in some sense guided by notice and comment, guided by a degree of political accountability that is necessary for the administrative state to at least have a plausible claim to be consistent with our underlying constitutional values. Section 553 of the Administrative Procedure Act, for example, sets out a set of baseline default rules for those of you that practice in administrative law. This is nothing new. Requirements of that agencies provide a notice when they are going to engage in a rulemaking, that they allow for public comment, that they respond to those comments, that they issue a concise general statement that is usually anything but concise, explaining the final rule that they issue, and that they even provide a period of time between the issuance of the final rule and its effective date. The purpose of these requirements is to ensure that this rulemaking process, this policy-making process, what in many respects we can characterize this legislating process, this creation of rules that bind private behavior, still have some degree of political accountability, that those whose conduct is going to be bound, those who may be subject to civil or even in some cases criminal punishment, can be made aware of what it is they must comply with, that they have the opportunity to provide feedback to the agencies, not merely to challenge the agency's policy judgments, but often, as we've learned, to inform the agency of things the agency did not know. Another pervasive problem of the administrative state is that centralized agencies do not have access to the full range of information necessary to make the sorts of policy judgments they are called upon to make. And we've seen many instances of the notice and comment process providing agencies with information that they were simply not aware of. One of my favorite examples involved when OSHA was imposing regulations on dry cleaners and learning that, in fact, there were ways that were to deal with the relevant emissions that were 1/10 the cost of what their desired or preferred opportunity was. It's something they simply hadn't known until they issued a proposed rule. And folks in the industry said, oh, hey, by the way, some of us have actually dealt with this problem. And we can do so in a far less expensive way than you'd come up with. These procedures are also designed to help ensure reasoned decision-making, that agencies are, in fact, asking the questions that Congress wants them to ask. And of course, this process also facilitates judicial review. It provides reviewing courts with a record that they can evaluate, with reasoning that can be evaluated, so that judges are more able to evaluate what agencies do on their own terms rather than to substitute their own policy judgments for those of the agencies. Now, Section 553 of the AP has a catch in that some of these requirements expressly don't apply to interpretive rules and to policy statements. The idea being that agencies can do two sorts of things. They can enact what we should really just call legislative rules, those things that bind the public, those things that impose obligations, define relevant rights, and those things that really try and clarify pre-existing obligations. Those that, put another way, there are those agency actions which reiterate, explain, clarify pre-existing legal obligations created by statute, and those that actually impose new obligations or alter the scope of those obligations. The problem is that agencies realize that a lot of times when they act, what matters for judicial review or what matters how things are evaluated is not what the agency is actually doing, but what the agency calls it. And so for quite some time now, we've seen agencies engage in the practice of calling something an interpretive rule, a policy statement, a guidance. In one recent case, it was letters to a senator, really calling these policy statements when in fact what the agency is doing is imposing obligations, expanding obligations, changing the rights, redefining the rights that private parties have. And agencies have become quite clever at doing this, issuing rules that are no more explicit, or clear than the underlying statute, and then subsequently issuing a guidance document or a policy statement that purports to clarify the ambiguous rule, purports to take advantage of various deference doctrines that allow agencies to interpret their own regulations, and then to do all the heavy lifting in terms of defining rights, not through the notice and comment process, but in a document that's perhaps issued on a more ad hoc basis. And the problem when agencies do this is that it undermines transparency and accountability, it frustrates judicial review, and it makes the administrative state less compatible with the underlying principles of our constitutional structure and the separation of powers. A question I only have a couple minutes is, well, what do we do about this? The Administrative Conference has looked at this problem to some degree, although I would think it's fair to say has not been particularly aggressive in its recommendations, at least thus far. It has suggested things like trying to encourage agencies to issue guidance documents contemporaneously with regulations to actually include the guidance actually in the rule itself. Actually let regulated entities know what they have to comply with when you impose the rule. Go figure, who would have thought of that? But agencies, again, have been resistant to this. When Susan was at OMB, she certainly tried to get agencies to be more responsible about issuing guidance, providing guidance documents for OMB review, including putting guidance documents in notice and comment, but it's difficult to do. Courts have become somewhat wise to this, and there are certainly in the D.C. Circuit in particular, there are a series of opinions that try to follow the advice of at least some commentators, like the late Robert Anthony, who I think wrote about this in greater detail and with greater clarity than anyone else, focusing on what is it that an agency actually did, as opposed to the label that the agency attached to it. And to say quite simply, if what the agency is doing is purporting to impose an obligation to define or limit a right, then it is a legislative rule that must have gone through these processes, and if it has not, it is not a legislative rule and it is void. But again, that is difficult to do, and that agencies that are aware that this is the way they will be evaluated may play various games. My favorite is the issuance of the draft guidance that then just sits there for years. It's clear to everyone that this is what the agency will use when deciding whether to bring an enforcement action, when deciding what is or is not compliant behavior, but it's not a final agency action, so it's not subject to judicial review. And even if it were, the agency would claim this is merely a guidance, this is merely a policy statement, this is not the legislative type action that is required to go through Section 553 in the first place. Ideally, we would have more formal requirements for agency use of these materials, require agencies to, in fact, combine a lot of the policy statement and guidance process in the rulemaking process, so that we would not be dependent upon courts being willing and able to catch each and every instance of agencies doing this. As I mentioned, there's an 8th Circuit case from about a year ago where the 8th Circuit found that some letters from the EPA to a senator that for the first time made explicit what the agency's, the way the agency was going to apply various portions of the Clean Water Act were in fact an effort to engage in rulemaking without notice and comment, and the 8th Circuit struck that down. But I think it would be folly to assume that courts will be willing and able to catch each and every instance of this. And this is a larger problem because the Administrative Procedure Act has largely served as a safeguard for the administrative state that has enabled us to avoid thinking about some of the larger problems which lurk in the background, which is what are the real requirements of due process that agencies must follow before they take actions that impose obligations, define and limit rights. The Administrative Procedure Act, by kind of setting forth a set of rules and requirements, and I'll close with this point since I see I'm out of time, has basically said, well, so long as agencies go through these requirements and follow these procedures, we can be assured that whatever it is the due process clause requires, that's been met. But the more aggressive agencies become at trying to avoid the APA, the less we can be sure that agency activity is, in fact, not merely compliant with the principles of the APA, but compliant with the underlying principles of due process that agency conduct should be forced to comply with. And my concern is that insofar as agencies pursue this course, they will force us to deal with some very difficult questions, and questions that courts have largely been able to avoid, but questions that really strike at the heart of the nature of the administrative state and how it should be controlled. Thank you.
Thank you, Jonathan. Bill Kovacs.
Well, good morning, and thank you, Susan, for inviting me, and thank you to the Federalist Society. I'm going to talk about sue and settle, which is Before I actually do that, let me do an advertisement. Here's a book that we published on Sue and Settle, and the reason we did it is because there is no database in the entire federal government is to tell you what cases they actually settle, especially those cases under Sue and Settle. And I think as you browse through it, you will find that most of the major rules in the environmental area have come out of a Sue and Settle agreement and not out of necessarily the direct Administrative Procedure Act. Having said that, Sue and Settle is something that all lawyers are probably very familiar with. Every day in private practice, you sue someone, you have an agreement, you either file a settlement agreement, you file a consent decree if you want the court to enforce it, and you move on. They're private party settlements, the court rubber stamps it, and you move on with your life. When you do something like this in the public policy arena, you literally are beginning to change how public policy is made, what priorities the agency has, and how they reprogram their budget. Nothing like this is discussed anywhere in the Administrative Procedure Act. So how did we get into this? And so what happens is, in practical terms, an environmental group, because they have citizen suit provisions, sues a federal agency. The agency does not use its discretion to defend, or even its discretion to negotiate what the time might be for the implementation of a rule. Rather, they settle. All of the discussions are in private. They file the consent decree with the court. No one until this point in time knows anything about it other than the NGO and the agency. Some statutes require, after it's been filed, to have some comments, but the comments don't even have to be brought before the court, and then the settlement agreement is implemented, and it's literally rubber stamped. I think there's only one instance where a court actually tried to do anything that disturbed what was filed by the agency and the environmental group. So, how did we get into this, and why do we care? Well, we've been watching, there's a court out in the Northern District of California in Oakland that was starting to get a variety of cases relating to regional haze, and states like North Dakota and New Mexico were implementing their own regional haze agreements, and finally the environmental groups were suing EPA in Oakland without any notice to the attorney generals of the state, the governor, the secretary of state. There's no notice at all, and entering into consent decrees in which a court in Oakland, California now has jurisdiction over EPA and its programs in North Dakota and New Mexico, wherever. And when 5 of these cases went through, we started asking a very simple question: how did this happen? And then when the same court issued a consent decree for 28 hazardous air rules in one consent decree, we thought we would begin asking questions. What is this about? And we went to Justice, we went to EPA. There's no database anywhere in the federal government, and they will tell you they can't do a database because everybody settles a case differently and they have no idea, even though these cases all result in major rules. So we came to the conclusion, one, there's no transparency, we didn't know. There was absolutely no right to public participation. And what was the most disturbing is when the agency signs the agreement, they completely lose their discretion. They have to implement that particular rule. And when they do it, there are only 2 parties, if they don't implement it, that can have a stake in getting it implemented or enforced, and that is the court or the environmental group. The regulated community is completely out of the process. So we started asking more questions, and we started saying, well, should the states have a role, and how have you eliminated a state, taken over its program, and then put enforcement literally in the hands of an environmental group? And we found some interesting facts. One is 95% of all programs in the environmental field that can be delegated to states are actually being implemented by states. So they certainly have a stake. And the states foot 80% of all the cost. And yet, when they determined who was going to run that program in the state, it came down to EPA and an environmental group. So we became very concerned. But our concern was really, it transforms what we would consider a public entity that has discretion to implement many competing programs into someone that actually is subservient to a court order and someone who can enforce it through there. And to give you an idea of how much of an impact this has, EPA meets only 14% of its deadlines. So that if I've got a lawsuit and I can get a court order and that court's going to enforce it, and I now have the ability to go into court and enforce it, I can take my program and my rule and I can jump it ahead of everybody else's rule. And so when the EPA has roughly over a 10-year period, which was the study period, has issued 7,101 final rules, and it has entered 156 consent decrees to issue and implement rules. What rules do you think get effect? And so when you're thinking of this, you may say, well, they're minor rules or not, but if you go through the book, you will find that some of the major rules that have been issued in the last 4 years are all issued based on a sue and settle premise. Utility MAC, oil and gas MACs, Florida nutrient standards, regional haze, Chesapeake Bay rules, boiler MAC. I mean, the list goes on. And these rules, many times, would not have, had they gone through the normal process, might not have gotten the resources they need to go to the top. Because remember, EPA is competing with 7,101 rules, and all of a sudden they've got 156 that they're worried about. And in just the last 4 years, we had 60 rules over at EPA that were or 60 settlements that were responsible for about 128 rules. So the last part of the equation is, thank you. The last part of the equation is it not only, by going through the sue and settle process, it not only reprioritizes the agency's budget, it actually binds future administrations because it's now a court order and it's subject to the court order, and usually it says it can't be reviewed unless the environmental group in some way has participation in the process. No one else has participation. And by the way, the few times that industry has tried to intervene in the cases, we have been told that we do not have standing because just being subject to adverse rules is not sufficient grounds to claim harm. So what we have here and why we care is that we have a two-tiered regulatory process, one for the public, and they work through the APA and they get whatever resources EPA has, and once the rule is in effect, you've got your 60 days to file a petition for review, but basically you're subject to whatever they do. And then you have the second process, which is the sue and settle, where you have a group of private individuals who actually have a stake in enforcing a particular law. So that's sue and settle. What we're trying to do about it is the House of Representatives, the Judiciary Committee has been great. They've passed what is called the Sunshine for Regulatory Decrees and Settlement Act, and it does absolutely wild things. It allows the public actually to comment on a consent decree before it's given to the court. It requires the agency to inform the court what the public thinks and the regulated community thinks about it. And finally, it allows intervention if there is harm to the public or the regulated community and their interests are not being protected. But at least it begins to bring some transparency into the system anyway. I'll have time for questions later. Thanks.
Thank you, Bill.
Great. Well, thank you. Good morning. Thanks to Susan for herding these three particular cats. Thanks to all of you for coming. So I come at these questions from a slightly different perspective. I'm a federal courts scholar and teacher. And so one of the questions for me is what's behind this movement toward policy formation through litigation as opposed to policy formation through ordinary administrative processes? And before we even get there, are there problems as a legal or constitutional matter with this kind of approach? So I have two brief points I'm going to try to make this morning. The first is that whatever we think are the policy merits, there actually really isn't an Article 3 objection to sue and settle and other kinds of litigation-driven policy formation mechanisms. But second, that I think we have to see the whole field here to understand part of the pressures that might lead to this phenomenon. So let me start with Article 3. So most of you are probably familiar with Article 3's requirement of adverseness. The Supreme Court has always referred to it, but seldom actually explicated it. But the idea is that the federal courts are only supposed to hear disputes between parties that are truly adverse to each other, that actually disagree with each other, that aren't just there to use the court as a mechanism towards some predetermined end. There's a case from the 1940s called Johnson that stands for the proposition that Article 3 bars collusive litigation. And this is actually a fairly important part of the case and controversy requirement. But I think what's important to understand for present purposes is that the adverseness requirement can be satisfied even in cases in which the government agrees with the legal position of the private party that is suing the government, so long as there is still an adverse controversy. For example, if the government refuses to accept the consequences of that agreement. If the government refuses, for example, to pay money that would otherwise be due as a consequence of this agreement. And so you're all probably already thinking about last year's decision by the Supreme Court in the Windsor case, where Justice Kennedy, writing for a 5-4 majority, didn't mind that the executive branch had simultaneously refused to defend the constitutionality of Section 3 of the Defense of Marriage Act and refused to refund Edith Windsor the $363,000 in estate taxes that she would have been entitled to but for Section 3. From the majority's perspective, the fact that the government wasn't actually giving Windsor her money was all that was necessary to have a live case or controversy under Article 3, and despite the fairly bitter objections of the dissenters, I actually think that's supported by precedent. As Justice Kennedy explained, if the executive's agreement with a plaintiff that a law is unconstitutional is enough to preclude judicial review, then the Supreme Court's primary role in determining the constitutionality of a law that has inflicted real injury on a plaintiff would become only secondary to the plaintiffs. Would become only secondary to the presidents. Right? That is to say, right, Justice Kennedy's worried about preserving the role of courts as opposed to allowing a private litigant and the executive branch to go off and say, this is the rule going forward, there shall be no judicial review. So that's why I think having the consent decree is a big piece of this and why there's no constitutional problem. But also, I think it's worth considering what the alternative is, right? That is to say, would we prefer a world where the executive branch and private parties could enter into these agreements without any judicial review? Or is the answer, as Bill suggests, just more legislation to allow more parties to participate? I think that's an interesting question, but not ultimately one of constitutional significance. But let me turn to, I think, the more interesting policy question, which is, where is this coming from? How do we best ensure that federal agencies are following the rules Congress has created, not just as applied to them, but as enforced against the subjects of federal regulation? Let's remember why we're here. The whole question here is how the administrative state regulates the relationship between the federal government and regulated parties. So Bill talked about the EPA. I want to actually talk a bit about Medicaid. Not exactly everyone's favorite topic, but I think an interesting potential counterexample to the EPA side of it. So let's talk about Medicaid. So Medicaid, there are fewer than 500 federal employees who are tasked with supervising 56 different Medicaid programs, administering nearly $400 billion in federal funds every year. Out of necessity, most of these employees are concerned with bookkeeping and routine financial management of Medicaid funds at the state level, and not with actually looking at the 56 different state Medicaid plans to see if they are complying with the dozens of procedural and substantive requirements that Congress, by federal law, has mandated. And so the question becomes, how do we enforce those provisions? How do we ensure that these targeted subjects of federal regulation are actually complying with the rules Congress has laid down? Keep in mind that this is all during a time period during which expenditures for Medicaid administration have declined by 44%. Right? Congress has actually cut back Medicaid's enforcement budget by almost half, even as program outlays and program expenditures have grown, and at times, thanks to the Affordable Care Act, radically. Right? So we have this problem where there is a complex federal program being supervised by a small number of employees who can't possibly actually live up to ensuring that the federal laws are being followed. The question then becomes, how concerned citizens can ensure that understaffed and underfunded agencies, not all are, but I think the CMS is one example, are fulfilling their responsibilities to enforce federal law? We can certainly hope that the government adequately enforces federal law on its own. That is to say, we can hope that HHS goes around suing states. But there are lots of reasons why that just doesn't happen. Some of those are political. Some of those are legal, because the only way to actually go after a state that violates the Medicaid statute is to take away all of its Medicaid funding, which makes no sense if your goal is to protect the beneficiaries of Medicaid. One historical alternative has been to allow private citizens to sue the subjects of the federal regulation, as opposed to suing the government itself, directly, right? That is to say, to take up the mantle of federal enforcement on the government's behalf, a position that in the Medicaid context at least, HHS historically supported. Such private litigation allows the government more flexibility in setting its own enforcement priorities, and thanks to the Supreme Court's Brand X decision, to you administrative law junkies, in no way prevents the relevant agency from subsequently endorsing a different result, at least where the original private suit turns on some kind of ambiguous statutory text. This was exactly the logic of a 2002 en banc opinion by then Circuit Judge Alito in explaining why Medicaid providers should be allowed to privately enforce Medicaid's equal access provision, the provision that requires that states reimburse providers at a median rate compared to the standard of care in that vicinity. But the Supreme Court's recent jurisprudence regarding implied private causes of action and suits against state officers under Section 1983 has made this much harder, especially in the Medicaid context. Indeed, since that opinion by Judge Alito, then Judge Alito, there have been 6 different circuit court decisions holding that as a result of intervening Supreme Court opinions, private parties can no longer sue states or state officers directly under the Medicaid statute, and instead all of the enforcement prerogative falls on the federal government. And so all that remains for litigants who believe that these subjects of federal regulation are violating these laws is for those litigants to sue the agency. Right? That is to say that this is the option of last resort, is to provoke the very kind of litigation that leads to the sue and settle phenomenon that you heard Bill describe, even when the agencies may well agree with them, or more frankly, haven't had the time or wherewithal to even think about the underlying question. In other words, part of the sue and settle phenomenon may itself be a byproduct of other pressures disfavoring other, and I dare say, better enforcement mechanisms. Pressures that have been exacerbated by Congress's failure adequately to fund federal enforcement of certain federal mandates, and by the Supreme Court's recent hostility to any private enforcement of these same federal mandates. At the very least, in closing, let me just suggest that it's worth considering the extent to which sue and settle fills a gap for which other actors may well be equally responsible. That's not to condone it as a policy matter, but rather to suggest that there may be far more to this particular story than meets the eye, and that if our real goal is to figure out the most efficient way and the most transparent way to allow for the vindication of federal rights, we might want to think about what led to the sue and settle phenomenon in the first place. Thank you very much.
Can we rely on our mics now on the table for Q&A? Thank you. This was a very substantive set of discussions, and I'm looking forward to getting your questions and comments. But I'm just going to make one comment and ask one question. In response to Bill's concerns about sue and settle leaving the regulated parties excluded, I'd like to comment as a former official in the executive branch that it also leaves the president. So when these things get settled, it's often that the White House itself is excluded from, or it reduces the White House's ability to oversee the development of regulation. So I'm interested in what you think about that. And then I have a question for both of you. It sounds to me, you're talking about slightly different things. And this is not an area that I have particular expertise, but Bill, you're talking about agreements that guide how the agency establishes the rules that apply to everyone, whereas Steve is talking about agreements that require enforcement of rules that are established. If you have a brief comment on that, I'd be interested.
Sure. Well, first of all, in terms of leaving the White House out, it not only leaves the existing administration out, it actually binds future administrations, and that's something where Congress can't bind future Congresses, but all of a sudden the courts can bind them and can bind the White House. So that's really our primary problem. And in terms of why we care about the rules, and you're right on your analysis, I think we are talking about different parts of it. We're concerned the fact that this has been a mechanism by where you reset agency priorities for the issuance of rules, and that's something no one else outside of the sue and settle process can really do.
So let me just jump in on that. I mean, I do think they're different. I mean, if anything, right, Bill, I think there are different phases in the process where these problems are arising. The only thing I'll say is, if the question is the resetting of priorities, I think the question I'm trying to raise in my comments is, how do we think about this from the perspective of ensuring that underlying federal mandates are actually being enforced, right? That is to say, when you have a question about presumably an agency's responsibility to ensure that certain subjects of regulation are complying with specific federal mandates, who's in the best position to hold the agency to account? I'm not sure the answer is a private party suing the agency. One answer is a private party suing the subject. Right, and saying, that the subject of the regulation is violating federal law. All I'm trying to suggest is that I think there was a vacuum that was arising as a result of these pressures, and that's part of my concern is, how do we fix that vacuum, right? How do we actually come to some kind of settlement on the proper way forward, not just for how agencies articulate their priorities, but for how those priorities are then turned around and enforced against the subjects of the regulation.
John.
Yeah, I was going to say, to add this, certainly, I think Steve hits on an important point, which is some of this is a problem of Congress's making, in the sense that Congress enacts statutes that impose more obligations on agencies than agencies have the resources or personnel to fulfill. And a lot of these obligations are non-discretionary. And so then the question becomes, how is the agency, if the agency is required to do 10 things in a certain period of time and has the resources to do 3, how is it going to make that decision? And there are lots of different ways we could envision the agencies making that decision. But since Congress has created these various citizen supervisions, and because there is a presumptive right of judicial review under the APA, litigation ends up serving that function, and it actually acts as a trump on the other ways of setting priorities, that being internal agency decision-making or political priorities by the administration. Using the judicial process as a way to trump that, and it's one that, at least in some contexts, Congress deliberately created. That is to say, Congress wanted to prevent administrations from being able to substitute their priorities for Congress's priorities, and so Congress created mechanisms to allow courts to work with outside interest groups to do that. And that's, I think, qualitatively different from citizens engaged in kind of enforcement of pre-existing rules. One area where I think this creates a particular problem, though, and it ties to and settle into my remarks, is when in the context of settlement, the agency is not merely agreeing to conform its actions to a set of priorities determined by litigation. Are we going to do Rule A before we do Rule B? But in fact agrees in the context of the consent decree to reach certain conclusions, certain outcomes that are themselves supposed to only be the result of the notice and comment rulemaking process. And let me give an example of something that's in court right now. Oklahoma Attorney General Scott Pruitt is suing the Fish and Wildlife Service over consent decrees entered into with environmental groups over the listing of species. And part of the complaint is as follows. Under the Endangered Species Act and the existing regulations, when the agency is considering whether to list a species, it's supposed to be able to choose between 3 options. List the species as endangered because it's warranted, not list the species. There's also supposed to be a third option of warranted but precluded. That is, the agency can say, well, there is enough reason to list the species, but there are legitimate reasons to defer or delay making that judgment. According to AG Pruitt's complaint, that third option is absent from the consent decree. So what the agency has effectively done in the consent decree is altered the basis upon which it's going to make the ultimate policy judgment. And it's doing that not by going through notice and comment rulemaking and saying, okay, we're going to change the way we do this, and not because Congress told the agency to change, but because the agency and an outside interest group decided that the rules upon which the agency was going to issue its listing decisions would be substantively different than what the statute and existing regulations require. And that, I think, does raise a serious problem. It's not an Article 3 problem so much, but it's a serious problem about whether or not this process is used as a way not merely to set agency priorities, but actually to evade the rulemaking process and procedural requirements that Congress and perhaps even the Constitution require agencies to go through when making these sorts of decisions.
Before we open it up to questions, I wanted to ask our 2 people who talked about sue and settle. Jonathan laid out a lot of different areas where agencies are avoiding the legislative rule process using interpretive policies, et cetera. Do you have any thoughts or comments on that before we open it up.
I just have two brief comments, which is not to quibble at all with Jonathan's descriptive introduction, but to again suggest that there's a larger playing field here, right? Which is to say, I think part of this can be, at least in some ways, blamed on the Supreme Court for not taking a firmer stand on which agency positions will and will not get deference. I think that could have sort of foreclosed a lot of this a long time ago if the court had been much more authoritative about when an agency should and should not receive deference. And I think, for example, a case like City of Arlington is a real problem in this regard. But also, again, I think it's important to note that there are mechanisms for Congress, not on a case-by-case basis, but structurally, to act if either before or after the courts don't. And so it seems like, again, I would not put so much of the blame just in, I guess it's a sort of a pox on both your houses kind of response, right? Which is to say, I know that it's the inclination of this conference to blame it all on the executive branch and the, according to Congressman Cotton, anti-constitutional excesses of President Obama. In this case, I think it's structural separation of powers problems that have been latent for years, and that all three branches have both contributed to causing and could have found better ways to solve.
Well, I think the speakers hit the two nails on the head, and one is when Jonathan was talking about the role of Congress. The fact is what has happened is Congress has passed these very broad and vague laws and has asked the agencies to fill in the blanks. In essence, it has delegated an enormous legislative authority to the agencies, and then the courts turn around not knowing what to do because they don't really do science or economics, and they say, well, we're going to grant deference. So what happens in a divided Congress is Congress can't even really get its legislative authority back that it delegated, and the difficulty is now you're seeing courts not just in the citizen suit context, but in the APA context, like again in California, our favorite court. It was an FDA issue on food, no citizen suit provisions, no right of action, no anything. They used 706 of the APA and said, look, we're going to force you guys into a sue and settle situation. So what's happening is Congress is finding itself much less relevant in the situation simply because it has delegated so much authority, and now that it's divided, it can't get it back. And this is a long-term problem. And then when you hit on the deference, I mean, if you read the last three environmental decisions and the last one out of the Supreme Court, you're finding that the deference that is awarded is getting to be broader and not smaller.
I mean, I suspect we would all, regardless of one's political perspective, everyone has an agency they hate, right? And so
Only one?
We got a list.
I was going to say three, but then I was worried about counting the three. But my point is just right that I think everyone's going to inform this conversation with anecdotes about particular agencies that, based on their own preferences and worldview, cause particular problems. I mean, mine is more the immigration side of things than the EPA. But let me sort of go back to Medicaid for a second, because I think this illustrates the dead horse I'm trying to beat about the importance of meaningful private enforcement. So one of the central questions under the Medicaid statute is what equal access actually means. There's a statutory mandate for it, but the statute doesn't define it. HHS has never promulgated a rule saying what is equal access and what isn't. So when, for example, in 2008, California passed, as a matter of state law, a 10% across-the-board reduction in Medicaid reimbursement rates, there was a really interesting question about whether such an across-the-board categorical reduction violates the equal access mandate. One possibility is to say the agency has a responsibility to answer that question. The agency has to interpret the statute. The agency has to promulgate rules. I actually think we might prefer a regime where, through private litigation, that is to say, where a Medicaid provider or beneficiary sues California as opposed to the federal government and litigates it then, creating a record from which the agency can then act or not act, creating a decision that the agency will not be bound by under Brand X. That might be a better and sort of more transparency-forcing set of rules, insofar as it would give the agency more room to act. It would be more obvious what the competing narratives are, and it would provide for sort of less of an all-or-nothing proposition. The problem is that private litigation in this context has become so difficult because of the Supreme Court's recent hostility to private suits of any and all kinds.
Okay. There's a microphone over here, and we welcome questions.
Hi, I have two quick
And
questions.
can I ask everybody to say who you are and then state your question in the form of a question.
Sure. I'm Andrew Cluster with the Heritage Foundation's Legal Center. I have two questions related to, sort of at the 30,000-foot level, related to what I saw as broad agreement on certain parts among the panelists. Number one, you all seem to be somewhat ad law idealists. Professor Adler, maybe if we clarified or had additional APA rules, Mr. Kovacs, maybe if we relaxed standing, and Professor Vladeck, maybe if we had private enforcement, maybe we could reach some stable equilibrium where the rules would kind of work and things would improve. And I'm not sure that's right. So that's number one, is my question, is that an accurate assessment, that you all think that there's some sort of ideal system out there? And number two, you also all seem to agree, and this is interesting, that there's an increased role for the judiciary here. And a lot of development in ad law was, gosh, we just don't trust courts. But you all seem to suggest people should have an easier time getting into court, or courts should more aggressively police agency action, et cetera. So those are kind of my two questions.
Thank you.
Yeah, I think, there is underlying there is something more broadly, a debate about what the role of courts are and what the role of courts should be in this process. And kind of one of the conspicuous things in the room is the point of view that was espoused by Justice Scalia before he was a justice in a famous Suffolk University Law Review piece, where he basically, in responding to the D.C. Circuit's aggressive use of judicial review, said that standing should prevent a lot of these suits. And the D.C. Circuit's concerned that a lot of things that Congress has mandated simply get lost in the bowels of the agency. Yes, that happens, and that's a good thing, and the executive branch gets to do that. And I think a lot of people who would otherwise find themselves sympathetic to Justice Scalia are confronting the implications of that argument and are troubled by it, and as I think they should be. I think in terms of just arguing for a greater role of the courts, yes and no. I mean, courts have a comparative advantage at doing certain things. One of them is policing process. Courts are good at that. Those are questions they can ask. Did an agency, in fact, adopt a rule that purports to bind the public with the force of law? Did it follow the process for doing that? And we can expect agencies to do that with a greater degree of predictability and consistency than we can expect them to actually second-guess the policy judgments made by branches. So, yes, courts should do more, but we can't expect them to solve this problem entirely. But one reason why we want them to do this is because agencies are going to try and evade accountability and to do what they want to do. And we can debate whether or not that what they want to do is what's determined by the careers or by the political appointees or some combination thereof. And we want a structure in which the courts play a role in ensuring that agencies only do the things they were actually given the power to do. And as Steve noted, cases like Arlington make that much harder to do. Another Scalia opinion. Because they basically say to agencies, well, we're not going to worry about the type of question you're answering. If it's a question about the scope of your own authority, you get the same deference as any other sort of question of statutory interpretation, and that makes it hard. But that is one of the problems we have to deal with, is making sure agencies are only doing the things they are given the power to do, and that they're following the processes that they are required to follow.
I guess on your first part, would I want relaxed standing? The answer is really no. We're really hoping for more transparency, because we find that if you bring more people into the system, and the people really do care and they will participate. Our concern is, and the reason why we support the legislation, is the substantive laws that give the environmental groups prudential standing are not going to be changed. And so the only way you can really change it is changing how you make the playing field a little bit more equal. But in a perfect world, I guess I'd go back to more of the constitutional type standing, where you really have to be able to show the harm, as opposed to the prudential standing where someone just wishes it upon you and bestows it upon you, and then you go and wreak havoc, because it's not just rules. It's now starting to interfere with every permit that's being issued in the United States, just because one group has standing and no one else does. In terms of increased role of the judiciary, no, actually, I think that they really need to go back to their standard role of overseeing real harm in real cases that involve real parties that have conflicts, and that if there's going to be any greater authority, the greater authority needs to go to Congress, and they need to assume the Article I legislative authority, and they need to have control over the agencies, not the agencies having control over Congress.
So I'm not an administrative law idealist. I'm more of a judicial idealist. I'm a Fed courts person, so I think that's where I come from. I do think it's worth highlighting two things. One that Jonathan said, and one that Bill just said. The Jonathan point, I mean, there is a very real sense of Scalia versus Scalia here. And what I mean by that is I think it is a common misperception that standing doctrine, that administrative deference doctrines, that these doctrines are, I don't want to say political, but sort of one-directional. Insofar as which parties they tend to benefit and which parties they tend to not benefit. I think, given changes in who's in charge in Congress, who's in charge in the White House, and who's on the courts, in fact, they can often be deployed to benefit or harm anybody. And I think we're seeing some of the consequences of that in these recent developments. That's why I think I look for more of a neutral long-term answer, which I think is broader judicial review. Because I actually slightly disagree with Bill. I mean, I think courts can be transparency forcing in ways that behind the scenes administrative decision making isn't, or at least isn't necessarily. And I think courts are more inclined toward transparency in that context. And so to me, if the real question is the real parties who are really harmed vindicating their interests, I think we have to completely re-examine how private litigation is managed in the administrative state, and who's in the best position to enforce not just the administrative mandates the agencies decide upon, but the agency's responsibility to create those mandates in the first place.
Thank you very much. Yes.
Hi, Carrie Severino from the Judicial Crisis Network. My question is for Jonathan. I thought it was interesting your comment about the draft guidance gambit, where it's just something that's left in limbo in order to preclude litigation. And I'm curious how active courts are in calling agencies on that. The one example that came to mind was in the HHS mandate case. I think it was the D.C. Circuit, who they were going along on a proposed rule for forever, and they finally said, look, okay, we'll let you have until I think February, then you really have to make the rule, because they kept on claiming it wasn't right. So are there other cases, in the less controversial cases, where the courts are willing to say, fine, but this ends at a certain point?
Yeah, examples of that specific scenario don't come to mind, but there certainly are cases where courts have been asked to look at guidance documents, and there certainly are some cases where courts have said, you may be calling this a guidance, you may be calling this a draft guidance, but the way you're actually using it, the way it is being applied to private parties is greater than that. The problem is that, just from the standpoint of viewing this as a strategic game, the agencies, when they're doing something like draft guidance, are actually trying to evade accountability on multiple levels. One is guidance as opposed to substantive rule. One is draft versus final agency action. And so they're essentially trying to create a bunch of potential traps that just make it impossible for private parties to get review. And they sometimes get away with it because courts have an understandable reluctance to prematurely rule on substantive questions. And so if an agency can make a plausible case that they're still figuring something out, they're still trying to see how this actually works in the field, they don't really want to do the final guidance yet because this is complicated, and they're listening to the regulated industry, and they're discovering really how this should apply, a court's not in a really good position to say that to evaluate whether or not the agency's actually being honest in characterizing that in terms of what the agency's doing. And so a court has understandable incentives to want to say, well, we're not really sure this is final yet, or we're not really sure this is binding yet, and so we're going to send this back, and we're going to wait until someone can really claim that this is being imposed against them. Of course, in many contexts, this is the problem that Abbott Labs is trying to deal with. In many contexts, that's too late, and it's a problem because courts are inherently not in a good position to really figure out when is the agency trying its best to clarify and simplify what is truly a complicated set of regulatory requirements that Congress underspecified, and when are they trying to use draft guidance as a way of imposing pressure on the regulated community, forcing compliance by the agency's terms in a way that evades judicial review. And it's just difficult. And I think in the mandate context, because of the various deadlines, it was easier to call the agency on that. I think in a lot of cases, it turns out to be very, very difficult. And not having a clear set of procedures that agencies always have to follow when they do this gives them room to sometimes muddle through in good faith and to sometimes act in not good faith. And that's the way it works.
Any other comments on that?
John Malcolm with the Heritage Foundation. So this has been an excellent panel. What you've been talking about, though, are all things involving civil or administrative remedies. And I'm curious what other issues, problems, arguments that you see when regulatory agencies promulgate regulations that have criminal penalties attached to them.
It's an important issue. There's actually, I think it was from December in the Sixth Circuit, Judge Sutton had a concurrence in a case name which escapes me, raising the question about whether or not some of our traditional administrative law norms should apply when an agency has the ability to take actions that result in criminal penalties. That particular case, Judge Sutton addressed whether or not the rule of lenity should inform the way we apply Chevron deference, and I think that's an important question, and I would be inclined to say that where criminal penalties are on the table, that would be a reason to not apply Chevron with its full force. Whether that's compatible with the Supreme Court's Arlington decision, I'm not sure. And I think more broadly, though, I mean, there are larger questions that are raised when agencies have the ability to enact rules that result in criminal penalties that Congress does not have to in any way ratify. I mean, I think there are larger questions with delegation there that we've, up to this point, largely avoided focusing on.
I'll just say briefly, I think the one critical difference is that obviously a criminal defendant doesn't have to go out and find these rules, right? And what I mean by that is he'll have the full panoply of constitutional protections available to him in his defense. So if there's a meaningful due process objection to the rule, I would think, Jonathan, right, that there might be a serious vagueness problem if you had a context where it wasn't reasonably clear to the defendant that what he was doing was unlawful given the agency's, the way in which the rule was formulated. So actually, I mean, I guess I'm less worried in the criminal context only because we have clearer rules and norms about the importance of the defendant being fully apprised of his conduct and having a full opportunity to challenge it. Doesn't mean it's not a problem. It just means that I think I put it lower on the list of things I'm worried about.
Yeah, let me push back on that, because I think the issue, I mean, if we're talking about the criminal defendant that's actually charged, okay, I agree with you, and the court has a case next term whether or not allegedly throwing the fish overboard violates Sarbanes-Oxley, the anti-shredding provision in Sarbanes-Oxley.
Depends on how you prepare the fish, right?
Right. But there's a larger issue, because when criminal penalties are on the table, what we're concerned about is not simply when the agency actually engages in the enforcement action, but when the agency shows up and says, by the way, if you don't do things the way we say, whether or not that's what our rules actually say or whether or not our rules are actually clear, you have the prospect of a criminal enforcement action. And that radically changes the interaction between the regulated party and the agency. And that gives the agency a lot of leverage that we should be concerned about. I mean, part of the underlying problem with agencies taking any sort of legislative type action without process is not merely what ends up in the Federal Register, but the way it affects the interaction between the agency and the regulated party in anticipation of an enforcement action. And when a criminal penalty is on the table, that radically changes it. I mean, the Fish and Wildlife Service sends a landowner a letter saying, oh, we might fine you. That's a radically different experience than when they send a letter to the landowner saying, oh, and by the way, here's how long you could go to jail, but we're not telling you violated the law, we just want you to know. And we should be very concerned about that, because that sort of interaction almost always occurs under the radar. It's not subject to judicial review, and under cases like Wilkie versus Robbins are very hard to bring to the courts, but really go to the heart of whether or not the administrative state is acting in conformance with the ideals we've set forth.
But why wouldn't there be? I mean, why wouldn't there be a declaratory judgment action available once there was a threatened prosecution?
Well, there doesn't even necessarily have to be an prosecution. I mean, the Endangered Species Act is a very good example of this. The standard practice of the Fish and Wildlife Service is often to send a letter saying, hey, your land seems to us to look kind of like the sort of habitat that this species like. Now, we don't know if there are any species actually there or not, because we haven't had time to look, but if there are, and if you modify that land in a way that causes actual harm to a species by habitat modification, here's a list of all the things we could do to you. Have a nice day. And the person, what does the person do? Well, the person, I mean, they can hire their own biologist and spend thousands of dollars to actually answer the question that the agency hasn't answered. If they go to the agency is going to say, hey, we don't know. And we're not required to know because we can take an enforcement action after the fact if we discover you violated the law by causing actual harm to a species. And so what declaratory judgment action do you get? That if you in fact harm the species, you would be subject to criminal prosecution? Well, we know that's true. Are you going to get a declaratory judgment action about whether or not the species is actually on your land? Again, how would you do that unless you want to spend the tens of thousands of dollars to do the research yourself, which may be research that in fact gives the agency the information it needs to prosecute you? I mean, these interactions are often occur in contexts in which those sorts of remedies are unavailable. I mean, cases like Sackett help a little bit, but I think the texture of these interactions is such that it's really problematic especially when criminal penalties are on the table, because then it alters the calculus in a way that simply increasing or decreasing fines and that sort of exposure does not.
But I think, look, I don't do criminal law, but in every single environmental statute, you have administrative penalties, civil, and criminal. And if there is anything that is always on the table when you run an environmental business, you run a hazardous waste treatment facility or whatever, you know that there's always criminal penalties. And that's one of the, if there is a problem with the administrative state, it is that's always lurking there at the penalty phase. And that is one of the reasons why there is so much fear in the system. And the fear stretches way down. It stretches to you don't want to challenge the agency when they give you something unreasonable to do. You don't want to testify before Congress. I mean, it's the underlying fear that is associated with every violation, because every violation in the environmental field is criminal if they want to make it that.
I think this is something that we can maybe come back to if we'd like, but let's, when we still have 10 minutes for questions, so.
Thank you very much. Wayne Abernathy, American Bankers Association, the older ABA. Really appreciate this panel. You've raised just a variety of, I think, very important questions. I'd like to draw attention to an international one that we have seen, seems to us to be increasing, where a regulatory agency will go abroad, engage in some kind of negotiation with like agencies from other nations to create some sort of global standard. Then they bring the global standard back to the United States. It's not a treaty. It's just something that they've developed administratively. They will either enforce it through a regulation, which they will put forward for comment, but which they will be extremely reluctant to make any changes to because it upsets the international agreement, or they'll just take that agreement to guide their discretion as they go forward. How can we deal with the violations of due process that are inherent in that kind of procedure?
Well, that's a bit of a loaded question. Because I'm not sure where the due process violation is. But let me just say, I mean, I think there's a larger phenomenon that I think is not limited to this context of executive branch policy being used to displace not just ordinary business practices, but in fact state tort and contract law. And so there's a run of cases the Supreme Court has decided, the lower courts have decided, about basically the executive branch showing up when someone brings a state lawsuit against, say, a foreign insurance company, for example, and saying, oh, no, the suit can't go forward, it interferes with federal foreign policy. And the courts have, by and large, usually acquiesced and said, oh, yes, of course, that's right. And so there's a Supreme Court case from 2000 called Garamendi about California's effort to require insurance companies to disclose information about Holocaust-era insurance policies if they wanted to do business in California. So, I think, again, this is sort of one particular symptom of a larger problem, which is the ability of federal courts through federal common lawmaking to displace all kinds of otherwise existing priorities, state law, et cetera. The question then becomes, what do we do about it? Right? And that is to say, if you actually are so bothered by the notion of federal executive branch policy displacing state law, does that mean you believe California should be allowed to hold German insurance companies to account, even if the executive branch says no? If you do, does that mean you believe that states should be able to violate international law in the ways that they execute criminal defendants? I mean, right, so, again, there's a sort of apoliticalness to these questions that I think is often underappreciated. And my response is, if Congress has delegated the power to the president to do this, if the courts are willing to endorse executive agreements as a species of federal policy, then the ship has sailed. And if there is a due process violation, it can be litigated. But absent a due process violation, I'm not sure what the judicial solution is, other than congressmen who hold the president better to account.
Let me come at this a slightly different way. If what an agency is doing is adopting a guidance that effectively is going to bind the regulated community, it shouldn't matter where that guidance came from. That should be something that goes through the notice and comment requirements of the APA, or if you're in a statutory context of the Clean Air Act, the specific procedural requirements of that statute. And so an agency shouldn't be able to use the fact that something's an emerging international norm as a way of avoiding that process. I'm not sure the fact that the agency is influenced by a desire for conformity with other countries adds or takes away much to what the underlying procedural requirements should be. If the agency is using this as the way it's going to enforce its regulations, effectively changing the burdens on private parties, it should go through the process. There is a particular difficulty in some industries, and banking being one of them, where the agency's ability to impose really, really substantial costs in an unreviewable fashion on the regulated industry are such that the ability for the regulated industry to raise these sorts of questions is constrained. And I think that's fair to say that happens in banking, in the sense of when regulated entities are dealing with bank examiners and the like, in terms of when they're told what they have to do to be in compliance, there's really not an opportunity to challenge that in a way that is viable or safe for. And there are other examples of this. One that's often pointed to in the literature is drug approval. The stakes for a pharmaceutical company of a delayed drug approval are such that challenges to the agency that could result in a slowdown of drug approval are things that the drug companies just aren't willing to risk, and so that affects their willingness to challenge the agency on a day-to-day basis in terms of regulatory actions. But that's a separate problem. And so I think in the context of the bank industry, there's the one, are they just doing what a lot of agencies do, using guidance documents to evade the procedural requirements? There's a second context where you have regulated industries that, given their relationship with the regulators, are just not in a position to bring the sorts of legal challenges that we'd see in other contexts.
Okay, we have time for at least one last question.
Thank you. I'm Amit Narang, and at the risk of some friendly boos, I will say I'm with Public Citizen. I'm a little disheartened that I don't get any boos. Mr. Kovacs, I've seen you quoted in the press in the past expressing some disappointment that deregulatory measures have to go through the notice and comment process, and disappointment with the fact that that process is very slow and inefficient. I think you cited a statistic that's pretty telling. EPA missing 40% of, or only meeting, I should say, 40% of their deadlines. And so this hasn't been touched on by the panel, but it sounds like the panel is advocating for deregulatory measures to receive the same comprehensive, robust notice and comment process that pro-regulatory measures go through, and the panel seems to be advocating for, and also criticizing that a lot of the full panoply of agency actions, guidance statements, interpretive statements should be going through the notice and comment process. So my question is that the case that this panel would advocate for equal treatment in terms of pro-regulatory versus deregulatory measures, equal force applied in terms of the notice and comment application when it comes to deregulatory measures and interpretive statements and policy statements related to those deregulatory measures going through the notice and comment process? And then in terms of sue and settle, is the criticism of sue and settle something that would push, say, the Chamber of Commerce to forego the use of sue and settle in instances where agencies are missing deadlines and enacting deregulatory regulatory measures. I'll also make a plug for a piece of Scalia scholarship that I really enjoyed. I like a lot of Scalia's writings. It's very colorful. In 1981, when he was a professor, he wrote in the Cato Regulation publication that the incoming Congress under President Reagan should not be pursuing regulatory reform legislation because it would, in his words, entrench the status quo and would not allow a deregulatory agenda to proceed in the kind of efficient manner that the advocates for that agenda incoming Congress would want to see. Thank you.
Wow, I don't even know if I could repeat all of your questions in the time remaining. Let me see if I can hit the top parts, though. First of all, the Chamber has not participated in any sue and settle, so let's just get that off the table. Second, we have asked the environmental groups and Public Citizen and whoever else, not you directly, but any of the groups, to participate in the transparency of the process, and it's really the environmental groups who do not want the transparency, and they should, because all that does is bring the public in, and if you really believe in your position and what's being done as part of the consent decree, the public should be there. In terms of the deregulatory agenda, I've been very clear, and I think I've been always very consistent, that there should be a robust policy, whether it be to implement new rules or to repeal new rules. I think the courts would demand that based on the fact that the agency has to have a rational reason for doing whatever it's doing. Now, let's put all that aside and get to what I consider is the real problem. Right now, we're putting out about 4,000 new regulations a year. We have about 190,000 to 200,000. There's no human being in the world, and then that understands that process. You now have tens of thousands of guidance documents. You've got bank examiners walking in with their own interpretation. And the regulatory process is really something at this point in time where there is so much authority sitting in the agencies that it really becomes a threat to democracy, because the threats can start with the bank examiner and work their way up. And there are only two ways to do it. Either one, you go rule by rule through the process, which I would suggest is probably impossible, or two, Congress figures out how to get some control over the system and begins to really go through the laws that are on the books and really tries to understand. And I'll just give you one example. One of the reasons that, let's say in the Clean Air Act, that there is so much confusion is you have mandate after mandate. You have hundreds of mandates. So the EPA puts out the new rules for ozone, $1 trillion set of rules. 5 years later, it puts out another set. There's not even time for the communities in this country to get up to speed, implement it, get it going. Or you have PM, where they set a standard in 2013, and every single part of this country, except for California, has met the standard, and now they're going to do it again because we're in compliance. There's got to be some way in which we understand how irrational the regulatory process has become because of, one, hundreds and thousands, tens of thousands, probably millions of mandates that sit in these rules, a lack of understanding. Congress doesn't understand the regulatory process. The courts accept the fact that the agencies have this broad delegation. And so what you have is a system that is really beginning to crush people. And so when we talk about transparency, we're saying if a group really has a position, be honest. Look, at the Chamber, we tell you what our position is. Some days you like it, some days you don't. But we're transparent. We aren't pushing sue and settle and then doing sue and settle. And so I think that if there is any way in which the consumer groups and the environmental groups are going to preserve the kind of system they have, they're going to have to be somewhat more transparent. They're going to have to recognize the system is somewhat out of control, and no one can really understand it anymore.
Okay, we are out of time, but I'm going to ask Steve and Jonathan if they have a very brief last word.
Just very briefly, so Bill says we really need Congress to take control of the system, and I say, oh, please, God, no. That to me strikes me as the worst possible solution, is to have Congress micromanaging how federal administrative regulation works, right? That is to say, there's a problem here, but it's not a problem that requires completely reorganizing the entire administrative state. Not the least of which is because Congress is not exactly in a position to enact the number of rules and the specific variations and demonstrate the expertise that is so important in this field. So I think it's important to separate out what's the problem from what isn't. And I think the way to do that is by increasing the availability of judicial review, and not by suggesting to Congress that Congress should basically destroy the administrative state in favor of a congressional administrative state. Congress can't even run itself.
I don't know that I was saying that, but that's beside the point.
Yeah, just real quickly, I mean, I do think any agency action that changes obligations or rights under existing statutes should go through the same procedural process, whether we characterize it as regulatory or deregulatory. Insofar as, I would like to see deregulatory actions or, some way to minimize the accretion of additional obligations. I think there are other ways of dealing with that, and I don't think changing the APA on that score would do it. I don't think additional procedural requirements like mandating more cost-benefit analysis or more formal rulemaking is really a way of doing that either. I would disagree with Steve in that I think that there are things Congress can do that would impose more responsibility on Congress, that don't involve Congress supplanting the administrative state any more than the appropriations process requires Congress to necessarily micromanage each expenditure, and that reforms like sunsetting, like the REINS Act and the like, are the sorts of structural reforms which, above all else, just ensure that political accountability stays in the system. And I think that most of those that tend to, and I'm not saying this is true of Steve, but most of those who tend to oppose those sorts of reforms oppose them because what they are afraid of is that if members of Congress actually had to be accountable for the ultimate regulatory actions, that Congress would not choose to take the actions that agencies are choosing to take. And if that's true, well, that's the outcome that our system should produce.
John, I don't think the concern is that Congress wouldn't agree. I think it's that Congress couldn't handle it.
I think, we have a longer debate on that. I mean, I have a paper in the NYU Journal of, Law, Public Policy or something or other on the REINS Act that points out that the idea that sort of reform would drag Congress to a halt is really not justified. Congress is very capable of dealing with all sorts of things on an expedited basis when it doesn't think the decision requires a greater attention. But what it would change is accountability.
I guess I'm just more skeptical. I think if the president introduced a resolution in Congress tomorrow asking Congress to agree that every day ends in Y, there would be weeks of debate and perhaps a filibuster in the Senate. So,
Just look at the Reg Accountability Act, which does do a lot of the kind of process reform that you want in the Administrative Procedure Act. It's passed out of judiciary and really brings more of the public and more of the information into the system. Anyway. Advertisement.
I think we have a topic for our next executive review panel. Join me in thanking this panel.